ECOWAS Parliament set out to one of the community's jurisdiction to convene and deliberate on issues affecting the region. This time, it's Togo, the home of the current sitting Speaker of the ECOWAS Parliament. Over the years, the region has been confronted with several challenges ranging from inner dispute in nations, coups, and other things. As the 6th Parliament continues, the new Speaker meets a lot on a table. With a composition of both old and new MPs, the effective understanding of the Parliament, its function, powers, and limitations is crucial to addressing the ever-growing regional concerns. As such, the second parliamentary seminar of the 6th Parliament kickstarts with the topic Organs of the Parliament and their functions.
And there we have 5 organs. We'll talk to each one of them in a moment. The first one is the plenary. Now the plenary is unique in the sense that, well, these are the 5 organs. First, the plenary, the bureau, the conference of bureau, the standing committees, and the parliamentary groups.
Dr. Mohamed Gaba, after highlighting the many organs, agencies, and structural bodies, their functions and operational framework, navigated towards demystifying the difference between national assemblies and the ECOWAS Parliament.
Explain to you the difference between the functioning of a regional parliament and a national parliament. A lot of members come up to say, in our national parliament, X, Y, Z should happen. It cannot happen in this parliament. It cannot happen in this parliament. And let me make one point before I take my seat. One of my colleagues from the commission, I think who made the point that the institutions of ECOWAS are established by the heads of states. So the truth of the matter is that we are here at the behest of the heads of states. This is the truth. We are here at the behest of the heads of states. They establish us. They determine where our powers will stop. So that is a very important point that I think I must make in this induction training, so that it will help us in the next 3.5 years in whatever we intend.
With the notion that the ECOWAS institutions are at the behest of heads of states and governments, some MPs share different sentiments.
I was actually shocked at his concluding statement that the community parliament lives at the behest of heads of states. I still remember when I was subscribing to the oaths of these 6 parliaments. I vividly remember, I was trying to scroll it, I cannot get it, but there is a text that emphasizes that I should serve my community and should not be subjected to any authority. So I find that statement incongruous, if not contradictory, that I should not be subjected to any authority, but concluding that this parliament lives at the behest of heads of states. I begin to wonder where an MP might be critical to his head of state for excesses. How safe is that particular MP?
I'm curious, since we say we have decision-making body, this is for the legal folks, is the authority. Can you enlighten us how the authority makes its decision? I know in the United Nations you have the Security Council with vetoes. And this is germane. If you remember when we had the issue with the Alliance of the Sahel, which there was a division in the community. So that's an area that was not addressed, that we keep saying that that's the highest making body, the highest decision making. But how did they come to their decision?
The clear-cut dichotomy between the powers and functions of the authority of heads of states, ECOWAS legislature, and the ECOWAS court is still a thing many people are hoping to see full operation of the theories of separation of power within. The Community Court of Justice was created pursuant to the provisions of Article 6 and 15 of the revised Treaty of the Economic Community of West African States. Independent judges, who are persons of high moral character, make up the composition of the court appointed by the authorities of head of state from nationals of member states for a 4-year term of office. The mandate of the court is to ensure the observations of laws and the principles of equity, and to ensure interpretation and application of the provision of the revised treaties and all other subsidiary legal instruments adopted by the community.
It's not only restricted to cases that are brought before it, but a request for an opinion can be made by the authority of heads of state and government to the court on any issue regarding the interpretation of the treaty. The Council of Ministers can also refer to the Court of Justice for an opinion on any issue where there is a controversy.
Uzoamaka Obidike, representative from the Directorate of Legal Affairs, continues on the expanded jurisdiction of the court, which allows for individuals to approach the court on petitions and claims.
So, with the expanded jurisdiction of the Court of Justice, member states will bring an application, the Council will bring an application, the President of the Commission will bring an application, and individuals, for the first time, can bring applications. Also, corporate bodies as well. A national court in any of our member states may refer an application to the Court of Justice on the interpretation of a treaty or any community law.
However, with this mandate, the applicability and adherence of member states to the decision of the court has been a challenge for decades. With impunity, leaders trample on these decisions, many regional citizens say. A clear example is the Samsumana case in Sierra Leone. Hence, a member of the Sierra Leonean delegation, Honorable Abdul Kabo, mounted concerns on the biting powers of the court.
I just want to know which legal mandate or which punitive measures have been instituted in an event a member state or a community official goes against the ruling of the community court. Because on several occasions we've seen ruling being done by the community court and member states do not respect the ruling of the community court.
Another MP is also curious about the linkage between the Community Court and the Supreme Court in different member states.
The first presenter, I want to find out if there could be any linkage between ECOWAS Court of Justice and that of the International Court of Justice. I'm asking this because if somebody is tried in his or her own country, or the powers or the Supreme Court of the land exhaust its powers, what usually we find out is that straight away they go to International Court of Justice. We have ECOWAS Court of Justice. So what is...
With the wider range of powers the court is having, its biting tendency is a debate among many citizens in the region, as some leaders think it should be binding and others think it shouldn't. Samuel Tony.